check. Mr. Kramer, you may proceed.
May it please the court. As respondent's counsel, I've reserved most of my time to respond to a party that in this case has two very heavy burdens. The first is proving the underlying charges with clear and convincing evidence. The second is of reversing findings to the contrary as clearly erroneous. I will argue that the petitioner has failed to meet either burden in this case, that the evidence was insufficient to carry the burden in the underlying trial, that this case ought be dismissed based on the extraordinary prejudice from what Judge Hill found as an extraordinary delay that prejudiced my client, and that bar counsel should be stopped from prosecution based upon the fact that my client followed bar counsel's guidance in regard to the very same practice that bar counsel now seeks to punish. I believe that any sanction in this case would be unwarranted and actually send quite the wrong message to deter good behavior rather than to punish unethical behavior. This is a petition for disciplinary action that's 17 pages long. It contains 55 paragraphs of allegations charging 13 violations. It is a case that is overcharged and underproven. Bar counsel had to go back a decade to find but two innocuous lines to reissue writs of summons that appear to bear my client's signature. No one remembers these lines. No witness, despite the fiction that is contained in these allegations, no witness has testified that my client ever held herself out as a Maryland lawyer engaged in the practice of Maryland law, and Judge Hill found insufficient evidence to conclude either situation. Indeed, the clients in the underlying cases testified that Dawn Jackson had nothing to do with their cases. Indeed, in one case in which my client is charged with practicing Maryland law, my client actually happened to know this person, the client, and said, listen, I can't help you because I'm not a Maryland lawyer, but I can refer you to someone who is, that being Shervanti Jones in the case, a person who, if you read the petition, was unequivocally going to testify against my client, offered no such testimony of any kind. Bar counsel will no doubt tell you that laches doesn't apply in disciplinary cases. That's not the case. It is not the case where prejudice has actually been found below. And additionally, this is one of those cases where my client followed the recommendations of bar counsel on the very same matter. This is a case that challenges this court to decide what message it must send. Any sanction, I believe, would be counterproductive, because if the purpose of sanctions is truly to protect the public, what are we protecting? Why don't we encourage, as this court does in so many other cases, for bar counsel to pick up the telephone and say, hey, I've taken a different position than my predecessor did. I'm no longer enamored with your practice here in Upper Marlboro, and work to resolve the matter with an attorney that has always cooperated with bar counsel. We didn't need 3 years of prosecution, the time of 2 prosecutors, or taking up the time of 2 courts. We need, if we want to protect the public, to favor cooperation, not condemnation, to treat lawyers as professionals, not as criminals, which my client has been accused of in this case, to respect each other as colleagues, not as adversaries, and in the words of Lincoln, to be peacemakers, not warmongers who comb through old court records to stir up strife. Any sanction here would deter parties from working together on solutions to protect the public. It would not itself protect the public. And for that reason, I urge no sanction at all in this case.
Thank you, Mr. Kramer. Ms. Lawless?
Good morning. Good morning. May it please the court. Lydia Lawless. I'd like to start with noting that I did not file any exceptions to the findings of fact of Judge Hill below. So this court's review and the questions asked in the exceptions presented are strictly on this court's de novo review. And I'd like to start with my exception that I filed to Rule 5.5B1. And what that rule says is that an attorney shall not establish a office for the practice of law or other systematic and continuous presence in this jurisdiction unless authorized to do so. The facts are undisputed. In 2014, Don Jackson, a non-Maryland lawyer not admitted to the federal court in Maryland, established a law practice in Upper Marlboro, Maryland. Between 2014 and 2020, that was Ms. Jackson's sole law office. She used a Maryland address on all correspondence, on all court filings. She met with clients in that office. She was the sole owner of that law firm between 2014 and 2020. And she had sole control of the firm's attorney trust account. So the question is whether or not her practice, her establishing an office for the practice of law and her systemic presence, physical presence in the state of Maryland fits within one of the exceptions. And to sustain or to overrule the exception to 5.5B1 would be to create an additional exception to Rule 5.5 that doesn't exist. Currently, Rule 5.5D provides the exceptions by which an attorney may maintain an office for the practice of law in Maryland. And that's under two discrete and limited circumstances. One is if the attorney is in-house counsel and they're working solely for their employer located in Maryland. Two is if they are authorized by law, by federal law, to practice solely in federal courts. And as this court knows, that is not an unusual practice for a non-Maryland immigration practitioner to establish a law office in this jurisdiction and limit their practice to immigration law. That is not the case here. Recently, in Attorney Grievance Commission versus Thompson, this court was faced with a similar question. And in the Thompson case, it was a DC attorney not admitted to the Maryland bar, either the state bar or the federal bar. She practiced law exclusively from her home, located in Maryland, and used a Maryland mail drop or PO box address associated with her law firm. And what this court found was that she had established an office for the practice of law in Maryland and held out to the public that she was authorized to practice law in Maryland. This case is far, far more severe than the Thompson case. In the Thompson case, there was no evidence that the attorney met with clients in Maryland. There was no physical office created. There was no brick and mortar presence. There was no website by which the attorney advertised her her practice with a Maryland address. And so to overrule petitioner's exception, again, would just create an additional exemption and an additional exception to the rule that currently does not exist. And so goes 5.5B, so goes A.
Ms. Lawless,
Yes.
would you respond to the argument that bar counsel should be stopped based on the advice Ms. Ridgell gave when she visited the law practice?
Yes, Your Honor. And so the finding that Judge Hill made below was that Ms. Ridgell met with Steve Brennan, who was Ms. Jackson's attorney at the time, and Ms. Jackson in 2015. And the finding is that Ms. Ridgell instructed or advised or notified Ms. Jackson that she was required to have a Maryland attorney present at all times, and that they discussed business cards and letterhead disclaimers that would be appropriate. The undisputed testimony in this case, and if you look at Steve Brennan's testimony that he gave before Judge Hill, is that there was no advice given other than the letterhead and business card advice and having Maryland counsel present, and that Ms. Rigel specifically pointed the respondent to the Harris-Smith case. And that is critical, absolutely critical, because had Ms. Jackson taken the time to review the Harris-Smith case in 2015, we likely wouldn't be here, because the Harris-Smith case involved a non-Maryland attorney who established an office for the practice of law in Maryland with other Maryland attorneys. She was licensed to practice in federal court and limited her practice to federal court. She never entered her appearance in a Maryland case. What she did do, however, was she did all the screening for the firm. And what this court found was that a non-Maryland attorney could not do intake and screening at a Maryland law firm because it would be impossible to parse and dissect what would be the federal law versus Maryland state law. And this court found that Ms. Harris-Smith violated then Rule 5.5, which is the equivalent of our current 5.5A, and suspended her for 30 days. So I think that's
I'm sorry, can you refresh my memory? Did the hearing judge find as a matter of fact that Ms. Rigel directed the respondent to review the Harris-Smith case?
No, but that fact is not in dispute, Your Honor. Mr. Brennan testified to that. The second thing I would say is that estoppel does not apply. This court has considered that argument in Reddy. And unlike Reddy, where the respondent attorney had an extensive conversation with the bar counsel at the time about a particular and specific mechanism by which he was to repay loans, in a case where he was the subject or the target of an investigation, this case, Ms. Jackson was not the target of the investigation in 2015. Ms. Jackson was meeting Ms. Rigel to prepare for trial. She was meeting for trial prep, and it was an offhanded comment noting that she didn't have the required jurisdictional limitations on her letterhead and her business cards. Given the purpose of attorney discipline.
Ms. Lawless, isn't it undisputed, though, that after Ms. Jackson met with Ms. Rigel, she did, in fact, make changes in an effort to comply?
Yes, she made changes to her letterhead and her business cards, and she was not charged with violating any of those associated rules after she made those changes in 2015.
So she wasn't, so, and I know that the importance that your office is assigning to the Harris-Smith case, but it would seem to me a reasonable position would be that if bar counsel is sitting in your office giving you advice on changes to make, that would seem to be a reasonable response, notwithstanding what the Harris-Smith case says, if bar counsel is giving you that advice in real time.
Yeah, so I understand that argument. But what is not fleshed out in this record and what does not exist is there is no evidence that Ms. Rigel ever knew that Ms. Jackson's practice, that one, she wasn't admitted to the U.S. District Court in Maryland, and two, that her practice was not limited to federal practice. So it is also reasonable to say we have an attorney who establishes a brick and mortar law office in Maryland, invites bar counsel to come there to prep them. They are saying, I have this law office here under an appropriate federal exemption. And so she was never investigated, Your Honor. And so this is a side comment in a much bigger case that was ongoing at the time. She was never the target of the investigation. And quite frankly, Your Honor, this court in October 1 of this year, the new rules that go into effect have codified what has long been the practice of bar counsel's office, which is under Rule 19-711. If there is an investigation that is ongoing, that is reviewed under the inquiry under Rule 19-711 and closed by bar counsel, as opposed to investigated and closed by the commission, if any additional, further, or new information comes to the attention of bar counsel, that matter can be reopened. And so this is even more attenuated because she was never the subject or the target of the investigation. Her unauthorized practice of law was never the question that was presented in the trial prep of the Baylor case.
But given the facts, why wasn't she then?
Why wasn't she the target of an
Why
investigation?
didn't, yeah, after Miss Rigel came there or saw what was happening, why wasn't she investigated and sort of going into the reasons and nature of the delay?
Your Honor, I have no idea why she wasn't investigated at the time. I can't speculate to that. All I can say is that it must have been that everyone believed that she was authorized to have a law office in Maryland under the federal exemption. If we were to spend our time going into every law office where a non-Maryland attorney was established to practice law in the state of Maryland to investigate whether or not they were engaged in the unauthorized practice of law, we wouldn't be able to do anything else.
Yeah, but
Because
I'm not suggesting that, but she was there. She took the time to go to her office and she was on your radar screen.
Right, and the purpose of that visit was not to investigate Ms. Jackson. The purpose of that visit was to prepare for an impending trial.
Well, what occurred, Ms. Lawless, to trigger the docketing of Ms. Jackson's case and the bringing of this petition?
In 2018, Your Honor, my office received an anonymous complaint or anonymous correspondence that included a copy of Ms. Jackson's signature block for a case that had been filed where she was submitting pleadings with a Maryland address and printouts.
I think you might be giving us information that perhaps the hearing judge didn't include. I didn't know.
It's in the record.
Is it?
It's in the record, Your Honor. And received printouts from Ms. Jackson's website that did not have appropriate disclosures that she was not licensed to practice law in Maryland or that her practice was limited to federal matters.
Is that the case where she was actually admitted pro hoc vici?
I believe it turned out that it was a District of Columbia case that she was using her Maryland address in filing in the DC Superior Court. So no, there was one case where she was admitted pro hoc vice that was never the subject of an investigation. But once we looked at the 2018 information that was sent to the office, a judiciary case search revealed these two other cases where her appearance had been entered. And granted, it was years ago, but that certainly was not discovered until 2018.
And just to be clear, when you say it's in the record, did the hearing judge find as a fact this is what instituted this case?
The original correspondence to Ms. Jackson and all the follow-up correspondence is included in the record.
I understand. I'm just trying to determine, is this your view of what instituted the case, or is this the hearing judge's finding that you're relying on?
I'm not certain, Your Honor, if the hearing judge made a finding to that effect, but that is not a disputed fact.
Just wanted to clarify because I didn't see it.
Yeah, and I'm not certain it was a finding. Because quite frankly, I don't think that it's relevant because she has maintained a systematic and continuous presence from 2014 until 2020. In 2018 or 2019, she was notified that we were investigating whether or not she had any authorization to have a physical law office in Maryland. It was not until 2020 that she actually closed her office and moved out of, or opened a District of Columbia office to be able to have an address to use in the District of Columbia.
Did I see in the record that Ms. Jackson's counsel sent a letter to Bar Counsel in February of 2020 trying to ascertain or obtain guidance on how she could comply with the ethical obligations, and that was not responded to by Bar Counsel?
Yes, that is correct.
And then she opens her office in a DC office in March of 2020.
Correct.
And then you all filed this petition in April of 2020.
That may be the timeline.
So is there, I've looked at Mr. Grossman's deposition. Is there a difference in how your office is handling requests when something like Ms. Jackson's counsel asks for advice on how to comply? Is Bar Counsel not in the business of trying to assist in that regard anymore?
Judge Booth, Mr. Grossman's deposition testimony is not admitted as evidence.
But there is an exception to that. So assuming that we determine.
Yes, Your Honor. So part of my job, and as it has always been, is to provide education to the bar. As this court probably knows, I do an extreme amount of education, continuing legal education courses, and the like. I am not permitted to give legal advice. So in the context of a conditional diversion agreement where we are working to avoid discipline by remediating or rehabilitating an attorney, I will provide specific advice as to what it is that would satisfy whatever the issue is, the practice management issue, the attorney trust account management issue, or the like. This case, Your Honor, while we did not prevail on the majority of the charges in this case at the time that it was being investigated was not solely a question of the unauthorized practice of law and how Ms. Jackson could apply or could comply with Rule 5.5. This case involves serious allegations of dishonesty, of misconduct, of misrepresentations to the court. So that was but one small piece of what was originally being investigated in this matter and what ultimately was charged in this matter. And contrary to Mr. Kramer's claim that the delay has caused prejudice, in large part, Ms. Jackson has received the benefit of the delay because time has passed and witnesses could not recall and the evidence faded and we didn't meet our burden of proof. And so, Judge Booth, I don't have a policy as to whether or not I will respond to individual attorneys requesting specific legal advice about specific matters. What I can say in this case is we did not respond. So turning back, I guess, to the question about Ms. Rigel's 2015 communication with Ms. Jackson, this court decided the issue of estoppel in Ruddy. And this case, the Ruddy case is more compelling for an argument of estoppel because it was, one, a direct conversation with the Bar Council about the exact repayment plan that was at issue. And then the respondent attorney entered into the same repayment plan in a separate case and then was prosecuted for a conflict of interest in that second case's repayment plan. I would also point out that this court has long said that these types of defenses, the defense of estoppel, the defense of latches, the defense of advice of counsel, are certainly not defenses to attorney disciplinary cases because the purpose of attorney discipline is to protect the public. And in the unauthorized practice of law cases, it's to provide a strong deterrent message to non-Maryland attorneys that seek to open a law practice in Maryland. And so this case is really factually similar, not just to the Thompson case as it relates to establishing a law practice, but also the Johnson case. And the Johnson case was decided in 2001 or 2002, I believe it's cited in our papers. And in that case, the respondent attorney's defense was essentially what Ms. Jackson's defense is, which was that I possessed a Maryland law office, but I wasn't engaged in any Maryland law. And this court rejected that defense and found the respondent attorney violated Rule 5.5. As it relates to the other exceptions taken by my office, and they're sort of divided into two parts, one being the physical presence in Maryland and holding herself out as a Maryland attorney. And the second is the actual practice of Maryland law, the substantive practice of Maryland law. And Rule 5.5 forbids the substantive practice of Maryland law unless it falls within one of the exceptions in Rule 5.5C. And in this case, Ms. Jackson was engaged in the substantive practice of Maryland law. And the undisputed facts, again, are that she determined fees for Maryland cases. She prepared and signed settlement sheets in all cases, including Maryland cases, because she was the sole signatory on the attorney trust account. And she attended 15 settlement conferences in Maryland. That's in addition to her appearance being entered in the 2012 case.
In the settlement conferences, was she accompanied by a Maryland lawyer?
She was. And if you look at Rule 5.5 C3 would be the relevant exception. And what that exception says, that if the ADR settlement or mediation services are court annexed, that that a non-Maryland attorney is required to be admitted pro hac vice. And so she did not comply with that requirement and is in violation of Rule 5.5 by engaging in the substantive practice of Maryland law.
Ms. Lawless, were the
Yes.
settlement conferences that she attended, were those court conferences or were they mediation sessions outside the court?
Right. I think she testified that one was a private mediation. And as far as I understand, the other were court ordered in regular civil cases or family law cases in Maryland. The third exception that we took in this case really is just a subset of the unauthorized practice of law exceptions that she engaged in criminal conduct in violation of the professional business and occupations article in violation of 8.4b, and she engaged in misconduct that is prejudicial to the administration of justice in violation of Rule 8.4d. In reviewing these cases and reviewing the unauthorized practice of law cases, I do think that the appropriate sanction in this matter is some sort of suspension. And whether that's an indefinite suspension with a right to reapply in some period of time, 60 days as the Thompson case is, or a straight indefinite suspension, given the extent and the breadth of Ms. Jackson's practice of law in Maryland, I think is a question for this court. Because as far as my research has revealed, there is no case that this court has decided where an attorney who is not either licensed in Maryland federal court or associated with a Maryland attorney on Maryland matters has been charged with the unauthorized practice of law, or this court has discussed the charges.
How would this sanction contribute to the protection of the public?
The court has stated in discussing sanctions, obviously they're twofold. One is to protect the public, so that attorneys that are not licensed in Maryland don't represent or give legal advice to Maryland clients on Maryland matters. But second, and I think more importantly, as is frequently discussed in these unauthorized practice of law cases, is the deterrent effect. You can't come in and set up a Maryland law office unless you're a member of a Maryland bar. To do otherwise would really undermine not just the disciplinary scheme, but the bar admission schemes in many ways.
How is this not more akin to Harris Smith, where it was a reprimand and at least there were two factual considerations that Ms. Harris Smith didn't actually represent clients in Maryland court proceedings, and she had at least made some effort to limit her representation. And I guess given the extensive mitigating factors here, including the good faith efforts to rectify the violation, as well as the delay in disciplinary proceedings, I'm trying to figure out why this, assuming we were to impose a sanction, wouldn't be more akin to the Harris Smith case.
Sure. So the Harris Smith case was a 30-day suspension. It wasn't a reprimand case.
I'm sorry.
And in that case, Ms. Harris Smith was admitted to the U.S. District Court for the District of Maryland. And that is the case where this court discussed the question of the federal overlay, of the authorization to physically be practicing law in Maryland. Ms. Jackson never had any lawful reason to believe that she could establish a Maryland law office. And that is much more similar to the cases that are the Barney's case and the Johnson case and the Harper and Kemp cases, where you have where it isn't the federal overlay question, where you have non-Maryland attorneys coming into Maryland and establishing Maryland practices. And so I think it's much more similar, Your Honor, to the Johnson case, where Mr. Johnson was claiming that while he had a Maryland office, it was in possession only. And I would note that unlike the Harper and Kemp case, and unlike the Johnson case, Ms. Jackson was the sole owner and the sole named partner, and she operated the firm as a sole proprietorship for 6 years until she finally left Maryland or opened a DC office in 2020. So I do think a sanction is warranted. I do think that to find otherwise would be to create an unintended exception to Rule 5.5 and specifically to Rule 5.5D. And I would ask that this court impose a suspension.
Ms. Lawless, I just want to clarify your recommendation for sanction. If we sustain your exceptions that you've made here today is different than your recommendation that we have on paper. Is
Correct,
that correct?
correct.
And if we overrule your exceptions, what's your recommendation for sanction?
Then, correct, then we're left with the unauthorized practice of law charges from 2012, and I think we're more than in line with the Thompson case, which was a straight 60-day suspension.
Thank you.
Thank you.
Any other questions from the court? Ms. Lawless, I presume you've completed your argument?
I have, Your Honor. Thank you.
You're welcome, and thank you. Mr. Kramer?
Thank you, Your Honor. I recognize that Bar Counsel did not try the case below, but it's a little too late to try the case here in this court. I believe that Bar Counsel's command of the facts, particularly the facts found by Judge Hill, leaves a little bit to be desired. Judge Hill expressly found that my client spoke with Senior Assistant Bar Counsel Dolores Rigel, who said, listen, since you're not a Maryland lawyer, you know, you could probably do better than simply say you're only a member of the DC bar. It would be nice for you to add additional disclaimers to your business card, to your firm's letterhead, to your website, to say that you are not a member of the Maryland bar. And Judge Hill's findings, particularly at page 32, he stated the respondent inquired with Dolores Rigel, a senior assistant bar counsel, while she was meeting regarding the Baylor case. The petitioner did not call their former colleague, Ms. Rigel, to testify. It is difficult to believe that a member of the bar council would have a discussion of the nature of these allegations, yet that person took no action to stop, or at the very least made sure to follow up that no systemic presence occurred. Mr. Brennan testified that he thought maybe a Court of Appeals case was discussed in the first meeting. He was not present at the second meeting. But what he does confirm is that even at the first meeting, there was some discussion of, well, do you have Maryland lawyers on staff and the like? What we have here is a situation in which Ms. Rigel, acting under prior bar counsel, whose policy was obviously very different than the policy we're now hearing about from our current bar counsel, provided guidance on the very issue that my client is now being prosecuted for. This is a very different case than the Ruddy case. In Ruddy, bar counsel's statements did not directly address the same matter, and therefore were no more binding on bar counsel than ethics committee opinions. Here, as Judge Hill remarked to Ray Hine when Mr. Hine was making his closing argument, here we have the very same practice. If bar counsel has a problem with my client's letterhead or advertising or website, there were no charges to that effect at all, even brought in this case. But the bottom line is that you're trying to prosecute someone for following your advice. And more than that, to hold all that time that you allowed the practice to persist against my client to inflict even greater punishment. Our counsel has told you that she doesn't know why Dawn Jackson wasn't investigated before. I know why, and I think this court knows why. Because back then, things were handled in terms of finding solutions, alternatives to prosecution, guidance. Bar counsel's office had all of the information it needed. Certainly when you are calling an individual like my client to testify as a witness in another case, you know all about them. She knew, and the stipulation here and the finding is that Dolores Rigel knew my client wasn't a member of the Maryland bar. There's no dispute on that. Knew that my client was only a member of the DC bar. Knew that my client limited her practice to DC cases. Knew that my client had 3 Maryland lawyers on staff in that office. She knew about the Upper Marlboro office. She was there. The other problem with this case is indeed, as Judge Raker had observed, the enormous delay. And this is a case very different, say, than the Kahn case, where this court recognized that the defense of laches does apply in disciplinary cases. It just didn't apply in the Kahn facts, because there was insufficient evidence of any prejudice from what the court believed was a gross and inexcusable 2-year delay. By contrast, we have findings below of, quote, the prejudice resulting from extraordinary delay, which Judge Hill found was, quote, particularly evident from the record. The length of time, as Judge Hill wrote, put Dawn Jackson in the awkward position of trying to defend her actions when, in fact, she couldn't recall them either, and no witness could recall them. In fact, bar counsel, who pled much of the case upon information and belief and promised that there would be witnesses who would corroborate that information and belief, failed to produce any of them. In fact, all witnesses called by both sides testified that Dawn Jackson never practiced Maryland law, never portrayed herself or held herself out as a Maryland lawyer, that there was no evidence that respondent ever appeared as counsel in any Maryland case, and she never appeared in court. And I should also say that the only testimony was that she did attend some mediations, but largely to shadow Stan Derwin Brown, who was kind enough to lease space to my client in his Caraway Court building in Upper Marlboro, and is an expert, a recognized expert in handling crime victim cases and negligent security cases, which is what my client was honing her skills in. There isn't.
Mr. Kramer,
Yes.
how do you respond to the, I take it, portions of the record that indicate that your client took care of what might be described as the back office functions as the owner of this firm that was based solely in Maryland?
There's absolutely no prohibition against handling back office functions. In fact, every large law firm known to man has people handling back office functions that are not licensed in the given jurisdiction. I should also say, Judge Biran, that one can administer an IALTA account from DC. It's expressly permitted. My client's back office functions would be no different than a non-lawyer handling back office functions. Most large law firms have administrators who aren't even JDs handling those functions. There's nothing wrong with handling back office functions, and it's not an authorized practice.
Well, maybe back office is perhaps not really what I mean, I understand what you're saying about non-lawyers being able to handle some, technical administrative things, but in terms of doing intake about what cases the firm ought to be taking, exercising some sort of judgment or discretion about the legal part, not necessarily going into court or entering your appearance, but doing what some might call legal work behind the scenes.
The only evidence presented at trial on this was that calls were routed, usually from a receptionist or legal assistant, to the attorney licensed to handle a given matter. So if something came in on a DC matter, it would go to Dawn Jackson. If something came in on a Maryland matter or an immigration matter or something of that kind, it would go to someone else. So the reality is that there wasn't any screening my client would conduct as far as the evidence is concerned. The evidence indicates, and all the witnesses testified, that cases were routed to the attorney licensed to handle them.
Mr. Kramer, what about the what's shown in the record with regard to the settlement of Maryland cases and Ms. Jackson's participation on settlements?
Actually, there isn't anything in the record on the settlement of Maryland cases, Judge Getty. The promise in the petition for discipline was that Shervanti Jones was going to say that, oh, all settlements had to go through my client. She testified quite the contrary at trial. And every single witness, Tiffany Sims, for example, called by petitioner, testified that no, my client didn't have any substantive involvement with any degree of settlement. The only thing that she would do is, because of the back office functions, she could say, well, listen, here's what the client will net. Because in a personal injury case or one of these negligent security cases or any of these cases, what the client's going to net after expenses and the like matters a lot. But that's not a question of law. That's just a question of firm accounting. We have this much in expenses. And certainly if my client needed to approve some write-off of expenses, she could do that. But that's not a legal function. That's a business function. And there's nothing wrong with that. And let's face it, there are large law firms out there that bar counsel wouldn't even think of prosecuting that do a whole heck of a lot more than what that would suggest. But the bottom line is, we're not talking about legal skill. We're talking about simply reporting, as Judge Hill found, reporting what the expenses were. There's nothing wrong with that. There was no evidence, no testimony from any witness called by either side that said my client had to approve the settlement of Maryland cases or participated as counsel in mediations. Quite the contrary. So we have to go with the facts that were produced and the facts that were found by Judge Hill, and no finding to the contrary was found.
Mr. Kramer,
Yes.
are you asserting here that a member of the Bar of the District of Columbia fits into the exception for federal courts and that the DC court system is the equivalent?
Yes, Your Honor, I am actually. And in fact, I think that Dolores Rigel was correct in the guidance that she provided my client for a couple of reasons. One is that if you don't hold yourself out as a Maryland lawyer, you can limit your practice to DC cases. This court observed in dicta in the Kennedy case, for example, applying Sperry versus Florida, that it wouldn't be able to limit the practice of federal law, or even to have someone, say in Silver Spring, as the lawyer in Kennedy practiced, if he limited his practice to federal and DC cases, that indeed may be okay. The
federal DC cases, not Superior Court, for example.
Well, there isn't a distinction. The Superior Court. Well, that's it. You see, I know we all assume, or it feels like a state. It's not a state. It's an Article I court. An Article I court that is authorized by federal law and is absolutely no different from an immigration court, from a bankruptcy court, an Article I court. Now, if this court were to take a different viewpoint, that's fine, but don't punish my client for that. Not to mention the fact that in every single case where this court has sanctioned a lawyer for the unauthorized practice of law, it was the lawyer holding him or herself out as a Maryland lawyer or taking on Maryland cases, not limiting the practice to DC or to what we traditionally call federal.
So you're saying that every member of the Bar of the District of Columbia who may or may not be admitted in any federal court fits into that exception and can open a brick and mortar office in Maryland, but only take DC cases.
So long as they do not hold themselves out as Maryland lawyers or engage in the practice of Maryland law, because those would then be cases in which this court has imposed sanctions for the unauthorized practice of law.
And it's because they, in your view, or probably you're right, are Article I courts. The same wouldn't hold true, for example, for the Commonwealth of Pennsylvania.
Absolutely not. It's not an Article I court. It is indeed a state. So if we are
Sure.
going to say,
Mr. Kramer, on that point, and I've looked at the dicta that you cited in the Kennedy case, wouldn't that be inconsistent with Attorney Grievance versus Thompson, the 2018 case where the court held that maintaining a home office with a PO box with a DC barred attorney did in fact constitute the unauthorized practice of law?
I'm glad you mentioned Thompson, because as Bar Counsel conceded in her brief, this case is not on all fours with this case, which is another way of saying Thompson's completely distinguishable. Thompson is distinguishable because in that case, as with other cases where this court has sanctioned lawyers for the unauthorized practice of law, the lawyer did hold herself out as a Maryland lawyer. And she even lied about it. She said, I'm just a bankruptcy lawyer. Well, they looked through the bankruptcy filings and she had no bankruptcy filings to her name. She was even handling a Maryland case in Thompson. So this case is nothing at all like Thompson. And it was surprising to me, after conceding that it's not on all fours with this case, that Bar Counsel would actually make the argument that this case is worse than Thompson. This case had absolutely no evidence whatsoever that Dawn Jackson ever held herself out or deceived any Maryland client into thinking that she was a Maryland lawyer. In fact, if you listen to Michelle Lyons' testimony, a case that Bar Counsel charged my client as having handled instead of Shervanti Jones, it is Michelle Lyons who testified that, no, when I discussed this with Dawn, who was a friend of mine and we'd worked together in another capacity, she said, listen, I can't handle the case. I'm not a Maryland lawyer. I'm not licensed to handle the case. I can refer you to someone who is. She gave her Shervanti Jones' phone number. And from there on out, it was between Shervanti and Michelle Lyons. No involvement whatsoever on the part of Dawn Jackson. This is exactly what you would expect an attorney to do. The public isn't harmed if the public isn't deceived. And the public was never deceived by Dawn Jackson. And no evidence has been produced below or anywhere indicating that the public was ever harmed by anything that Dawn Jackson did. What Dawn Jackson did was to cooperate fully with Bar Counsel in providing testimony in a totally different case, but also to follow Bar Counsel's recommendations. This is what you would expect a good lawyer to do. And we want to punish that practice? I don't think there's any basis for that whatsoever. Not in a case where all the witnesses in unison testified that my client never held herself out as anything but a DC lawyer. In fact, Judge Dolores Dorsonville, which some members of this court may recall, was at one time an assistant bar counsel, and at the time was an assistant disciplinary counsel in Washington, DC. When she was apprised of the charges, she said, I didn't think anything of it. I knew that she was always a DC lawyer. That is how she was known. Yes.
There is a Rule 5.5 violation. I know the trial court judge called it highly technical, but the trial judge also said no degree of legal experience or knowledge is required to follow a line to reissue a summons. However, that appears to be in conflict with Maldonado, the case that would say, yes, that is a legal act.
I wouldn't say it's a best practice, but what Judge Hill did find is that Ms. Jackson, there was no evidence that she participated fundamentally in any material elements of any Maryland case. And I will say this, we're at a disadvantage here. And the reason is that we're talking about going back close to 10 years to find these two innocuous lines that were signed by someone, perhaps Dawn Jackson, because it appears to be her signature, to reissue writs of summons. Nobody remembers it, all right, which is another problem of prejudice here, but no one remembers it. It certainly was not the most monumental of legal tasks, but more to the point, all we have is enough for authentication on that point. Judge Getty. We don't have clear and convincing evidence of exactly what happened with respect to those lines, which is part of the problem when you wait so long to bring any kind of charges or conduct any investigation. But also, more to the point, this happened in 2012. Are we going to encourage bar counsel to go back a decade, sift through old court records, much as Lincoln cautioned against, and stir up strife in that way on something like this? That's not why we're here. We're not here because of a couple of lines. We're here because upon information and belief, bar counsel accused my client of actually practicing Maryland law. But if I was to do something, I mean, frankly, if you were to look at a 10-year history of me or almost any lawyer, I would think you're going to find some mistakes. Is this court going to issue an opinion setting a zero tolerance policy for mistakes? I believe that there was perhaps a preponderance of the evidence to authenticate those signatures as being hers. But what we don't have is clear and convincing evidence of the circumstances surrounding it. And therefore, I have taken exception to even the finding of a highly technical violation. But I would also suggest that Judge Hill recognized that this was so highly technical, if a violation, that it's not really sanctionable misconduct in this case. The bottom line is that if we were to couple it with other indications that she truly practiced Maryland law, that she took some substantive role, that would be one thing. But we also know, Judge Getty, that from other aspects of Judge Hill's opinion, he said, I don't believe she did engage in the unauthorized practice of law. Obviously, he did find that highly technical violation. But I would suggest to this court that if a violation, it's so de minimis that it is not something one wants to sanction. And indeed, a sanction itself would create much more harm to the public than good. I think Judge Raker hit on this point in her questioning of bar counsel. The fact is that we asked bar counsel, we said, look, well, what can we do to correct the problem that you're perceiving now? We weren't interested in debating the nuances of the Upper Marlboro office. Just tell us what to do and we'll do it. And we get no response. Bar counsel believes she's not permitted to give legal advice. Obviously, she's also taken a different position from her predecessor on that point. We need to encourage dialogue. We need to encourage lawyers to work with the Office of Bar Counsel, not to follow their guidance at their own risk, not to be rewarded for their cooperation with bar counsel with a petition for disciplinary action and a request that they be disbarred, which is what the recommendation initially was here.
Mr. Kramer, in the event, and I'm not saying this will happen, but in the event that we sustain bar counsel's exceptions with respect to the violations, 5.5B, 8.4, the various sections, and overrule your exception, what would be your recommendation as to the sanction?
None whatsoever. And the reason is twofold. One is the extraordinary prejudice from the delay in this case, the estoppel, which if you look at Kahn and Ruddy, you'll see that there is more than ample evidence in this record to satisfy both defenses that this court has recognized would apply in the right situation in a disciplinary action. But more to the point, this court needs to ask itself, what message do we want to send? If our sanctions are designed to protect the public, how are we protecting the public by deterring Dawn Jackson and people like her from trying to work with bar counsel, from following bar counsel's own guidance in a case, own recommendations? We want to encourage that, not discourage that. This would set a terrible precedent. It is this court's disciplinary system. Bar counsel works for this court. And it's this court's responsibility to decide how it wants to administer that system. Does it want to encourage a prosecutor to sift through a decade of court records to find something to hang someone on? Or does it want to encourage an alternative way of resolving problems, much like ADR, in a disciplinary context, to work together? There was a time when bar counsel, I remember Mel Hirschman was famous for this, he'd pick up a telephone. And that was a way of solving problems. It didn't take 3 years of prosecution. It didn't take, well, 5 years of investigation altogether. It didn't take 2 prosecutors to go after a lawyer while ignoring requests for how can we make this right? That's what this case is all about. And it's this court's responsibility to decide how it really wants to deal with lawyers, as professionals or as alleged criminals. Thank you.